Hello, everyone, and welcome to our webinar on medical assistance in dying, particularly as it relates to some of the recent legislative changes with Bill C7. My name is Amanda, and I will be opening today's session and moderating your questions. Webinar events such as these are only possible with a strong team of individuals from within the CNO and inclusive of our stakeholders and members who continue to guide much of the work we do within the college. A big thank you to the professional associations and members who assisted us with the content for today's presentation and the materials that are now available on our website. Behind the scenes today, we have a team managing the slides and recording this meeting for posting and sharing broadly. By the end of this week, we will have the slide deck and the recording available for you. The first part of today's presentation will focus on the legislation as it relates to MAID. You will be hearing from our core MAID team within the college. Carlin Tanciocco is an RN and advanced practice consultant. Natalie Pellado is a nurse practitioner and educational consultant. Romy Sussman, a lawyer and policy analyst with us. And Eugenia Afralabi is a communications advisor who is also an integral part of our team, but will not be presenting today. Following the first segment on legislation, we will introduce you to a special guest, Diane, a nurse practitioner, who is joining us to share her clinical experiences in MAID. Next slide, please. As we are presenting this webinar in Zoom meeting mode, we are asking that you stay muted during the entire presentation. If you do have questions, please send them directly through to the chat to myself, Amanda Laird, as I will be moderating and theming the questions that arise, and we will bring them to our speakers for a response during the Q&A portion. If your question is not responded to during the Q&A, we will direct you to our Ask Practice webpage, and we will follow up with you directly. Enjoy the presentation, and I will now turn things over to Romy to get us started.
Hi there. Next slide, please. So this is an overview of the information we're going to cover in this presentation. We will have some resources, CNO resources available online, and links will be available to you. We're going to go through some of the history and background of medical assistance in dying, important changes that came as a result of Bill C7, going to go through the various stages of MAID, as well as reporting requirements in the process. And we will hear from an NP in practice to discuss issues of practice experience, and then we will have questions at the end. Next slide, please.
So to support your nursing practice, CNO has developed a number of resources, which includes Guidance in Nurses' Role in Medical Assistance in Dying, a document, an infographic, the MAID webpage inclusive of many FAQs, and we also have curated a number of external resources, and this is found on the MAID webpage. And we will send you an email with the slide deck and the resource list following today's presentation. Next slide, please. So what is medical assistance in dying? As many of you are aware, and to recap, it is defined in the criminal code and can be provided in two ways. Practitioner-assisted MAID, where a nurse practitioner or physician provides assistance by administering a medication to a patient at their request that causes their death, or patient self-administered MAID, where a nurse practitioner or physician provides a medication to a patient at their request so that they may self-administer the medication and in doing so cause their own death. Next slide, please.
So for the historical background, it was in June 2016 that former Bill C14 decriminalized medical assistance in dying for adults with decision-making capacity who were intolerably suffering and whose natural deaths were reasonably foreseeable. So this was a result of the Carter v. Canada case. Then in September 2019, the Superior Court of Quebec in Truchon v. Canada decision declared that the eligibility criteria of a reasonably foreseeable natural death was unconstitutional. So this ruling applied only in Quebec, but it was not appealed. The government determined instead to make changes to the criminal code. So the court suspended the declaration of invalidity for 6 months initially. However, this was ultimately extended several times before the final bill was passed. In October 2020, Bill C-7 was put forward, which was the government's response to the Truchon decision. It was initially introduced in February 2020, but progress on the bill's passage had been delayed due to the pandemic. So the October 2020 version is what was ultimately debated and amended. Then in March 2021, Bill C-7 came into force and received royal assent on March 17th, 2021. Next slide, please. So to highlight some of the more significant changes of Bill C-7, we are going to go into them in more detail through the presentation, but some of the main elements included the removal of the 10-day reflection period. There was additionally the removal of the eligibility requirement that a patient's natural death be reasonably foreseeable. So this created two tracks based on whether or not natural death is reasonably foreseeable. And those two tracks have had respective safeguards established. Additionally, there has been the explicit exclusion of mental illness as a sole underlying condition to be eligible for MAID, though this is time limited, as well as enhanced reporting requirements. Next slide, please.
So what changed? As Romy mentioned, Bill C-7 creates a two-track approach to procedural safeguards for practitioners to follow, based on whether a person's natural death is reasonably foreseeable, highlighted in the green, or their natural death is not reasonably foreseeable, non-RFND, highlighted in the orange. There are now ease safeguards for RFND and new stricter safeguards for non-RFND. The legislation does not define what a reasonably foreseeable natural death is. It is connected to time, but flexible, and must be assessed on a case-by-case basis in relation to the specific person who is seeking MAID, and must consider the whole individual and their unique medical circumstances. There are also enhanced reporting requirements based on the two tracks, which we will explore later on in the presentation. Next slide, please. So there are 4 stages in medical assistance in dying, and we will move through each stage as it relates to each track through the presentation. Stage 1, determining the patient's eligibility. Stage 2, ensuring safeguards are met, and by safeguards, we mean the measures taken to protect the patient and the practitioner. Stage 3, obtaining consent and the various types of consent. Stage 4, providing MAID. And finally, there are reporting requirements that occur at any stage. Next slide, please.
So for determining eligibility, these requirements apply for all MAID applicants, so to both tracks. The individual needs to be at least 18 years of age, have the capacity to make decisions with respect to health. They must be eligible to receive health services in Canada. They must be making a voluntary request that is not the result of external pressure. They would be giving informed consent to receive MAID and have a grievous and irremediable medical condition, which is defined as a serious and incurable illness, disease, or disability. They are in an advanced state of irreversible decline in capabilities, and the illness, disease, or disability or state of decline causes them enduring physical or psychological suffering that is intolerable to the person and cannot be relieved under conditions that they consider acceptable. So that is a subjective element that the individual feels that the suffering cannot be relieved under conditions that's acceptable to them. So in terms of what's changed from Bill C-7, it is largely the same eligibility as before, but the bill removed the requirement for the reasonably foreseeable natural death from that definition of grievous and irremediable medical condition, as well as the explicit time-limited exclusion of mental illness. Next slide, please. So prior to Bill C-7, mental illness as the sole underlying condition was not explicitly excluded from MAID eligibility, though it was very unlikely that an individual would meet the eligibility requirements. So for example, their natural death was likely not reasonably foreseeable. But Bill C7 clarifies that for the purpose of grievous and irremediable medical condition, that mental illness is not considered an illness, disease, or disability. So the federal government's clarified that mental illness refers to conditions that are primarily within the domain of psychiatry, such as depression or personality disorders, but it does not include neurocognitive or certain neurodevelopmental disorders. There is an explicit, a sunset clause on this explicit exclusion for 2 years. So this issue will be revisited in the future. So these individuals will not be eligible for MAID until at least March 17th, 2023. This temporary exclusion is going to provide the government with more time to study MAID on the basis of mental illness and how it can be safely provided, to come up with protocols, guidance, and safeguards, and then ultimately make recommendations on how this could be implemented. So it's not yet clear what this is going to look like in the future, or if there will be processes and safeguards in place by March 2023. So this is an important issue that will be evolving in the future, and good to keep eyes on going forward. Next slide, please.
So we are now moving on to stage 2, ensuring safeguards are met, and these safeguards apply to both tracks. The request for MAID must be made in writing and must be signed by one independent witness, and a person whose occupation is providing health or personal care services and who is paid to provide service to the MAID requester may be a witness, which can be an RN or RPN involved in the patient's care. 2 independent doctors or nurse practitioners must provide an assessment and confirm that all of the eligibility requirements are met. The person must be informed that they can withdraw the request at any time and in any manner. The person must be given an opportunity to withdraw consent and must expressly confirm their consent immediately before receiving MAID. And there is an exception to this, which is the waiver of final consent, and this will be discussed later on in the presentation. So to summarize what's changed, it is now 1 independent witness instead of 2 who must sign the written request. A paid professional, personal, or healthcare worker, including an RN or RPN, can now be an independent witness. And Bill C7 also removes the 10-day reflection period for the RFND pathway. Next slide, please.
So safeguards for non-RFND are in addition to what Carlin discussed. So there are those additional, more stringent safeguards. There must be 90 clear days between the eligibility assessment and the provision of MAID. This can be shortened, though, if the person is about to lose capacity. The assessment period begins and the clock starts on the day on which the first assessment takes place. So this could be triggered for example, by the MAID assessor reviewing the person's file, meeting with the individual, engaging in consideration of information that is going to form part of their assessment. The date of the beginning of the assessment period should be documented in some manner. So for example, on the patient's medical record, as it is expected that this will be requested through the federal monitoring regulations. A practitioner must inform the patient of available services and offered consultations. The individual and the practitioner must discuss reasonable and available means to relieve that person's suffering and agree that the individual has seriously considered those means, though the patient does not have to actually follow up or partake in those services or consultations. One practitioner must possess expertise in the condition causing the patient's intolerable suffering, though if neither practitioner assessing the patient has expertise, they must consult with a practitioner who does have that expertise and share the results of that consultation between them. Clarification on the expertise requirement. This requirement is for expertise in the condition causing the unbearable suffering, not just the condition that is the serious and incurable illness, unless it is causing the greatest suffering. Specialization or certification is not required. Expertise could be obtained through special training or previous experience with patients with similar conditions. But to be clear, only the MAID assessors are assessing the individual's eligibility for MAID. if a practitioner is being consulted for their expertise, it's on the medical condition. They're not assessing the patient's eligibility for MAID. So they might be advising on available types of services or treatments, the stage and nature of the patient's condition, or on the status of their state of decline. In terms of what's changed, this is a new track, so these are all new safeguards. And those are in addition to the earlier safeguards that Carlin discussed, which are applied to all MAID applicants. Next slide, please. So moving on to stage 3 and obtaining consent, like with any procedure or activity, consent is always required. Patients must be informed that they can withdraw their consent at any time. And immediately before administering MAID, the patient must be given an opportunity to withdraw their request and give express consent for administration. Bill C7 does permit waiver of that final consent requirement in specific circumstances. So for both tracks, as a backup in case of failed self-administration of MAID medication, which I'll go into in a little later in the presentation. And then when reasonably foreseeable natural death, if they fear losing capacity to consent. And Carlin will speak to this further. Next slide, please.
So what is an advanced consent agreement? An advanced consent agreement allows a patient who may lose capacity before their preferred date for MAID to waive the requirement for final consent if a number of conditions are met. And this applies to patients whose natural death is reasonably foreseeable. Practitioners must not implement the advanced consent for medical assistance in dying in cases where the patient demonstrates by words, sounds, or gestures refusal or resistance to the administration of the substance to cause their death. A demonstration of resistance would make the advanced consent agreement invalid going forward. If the patient regains capacity at a later date, they could consent to receiving medical assistance in dying at that time, as long as they continue to meet all eligibility criteria, or they could draft a new advanced consent arrangement with their practitioner. Bill C7 clarifies that involuntary bodily actions, such as twitching or physical recoiling from contact or insertion of needles, for instance, do not equate to resistance or refusal. Next slide, please.
So the other exception to final consent, which applies to both tracks, is for cases of failed self-administration. So this allows a patient to create a backup plan in case self-administration of MAID medication fails to produce death within a specified period of time, but they lose capacity in that process. So the patient can create a prior agreement with their practitioner to be present at the time that they plan to self-administer. And then that practitioner could administer medical assistance in dying if the self-administration failed and the patient lost capacity. So they could then administer meds in accordance with that prior agreement. And just to note that I understand in practice, self-administration of MAID medication is very rare for a variety of reasons, but this is still something to be aware of as the climate may change and this practice may evolve going forward. Next slide, please.
So finally, we are now at stage 4, providing MAID, which applies to both tracks. It's important to note that practitioners can be both assessors or providers. They don't have to be both, but many may act just as a MAID assessor. As you're all well aware, and to recap the general accountabilities of nurses, specifically nurse practitioners use evidence to inform decision-making about the medications that are used to provide MAID, ensure the safe disposal of unused medications, communicate with patients and families about the process, collaborate with the healthcare team, and ensure final consent. RNs and RPNs may also insert intravenous access for administration of medications, educate patients and families about the process, and most importantly, provide comfort and support to patients and families during this difficult topic. Next slide, please.
And on to reporting requirements. Reporting has always been required to Health Canada and the Office of the Chief Coroner, and that continues. Previously, this was done when a written request had been made. Bill C7 now requires reporting when any assessment takes place following a request. So not just a written request, but even preliminary assessments that are being done should be recorded and ultimately reported. Reporting also must be done regardless of the outcome. So if an individual is determined not to be eligible, they may change their mind or pass away from other causes, it is still to be reported under the new requirements. Bill C7 has also expanded the data being collected, including information on race, Indigenous identity, and disability. This is to identify individual or systemic inequalities and disadvantages in the MAID context. So while these federal reporting requirements are in the criminal code now, recent information from Health Canada has indicated that they're in the process of updating these regulations associated with MAID reporting. So the new reporting requirements are going to come into force with those regulations. Health Canada does have information available online on how to proceed in the interim, and more information about those requirements. Next slide, please.
So the law does not compel an individual to provide or assist in providing medical assistance in dying. Nurse practitioners, registered nurses, and registered practical nurses may have beliefs and values that differ from those of a patient and may not be comfortable providing or participating in medical assistance in dying. Therefore, a nurse may conscientiously object. Conscientious objection should be based on reflection, moral concern, and informed choice, not upon fear or convenience. Conscientious objection must not be directly conveyed to the patient, and no judgments about the beliefs, lifestyle, identity, or characteristics of the patient should be expressed. If nurses can anticipate a conscientious objection to MAID, they have an obligation to notify their employers as soon as possible, or in the case of self-employed nurses, inform persons seeking MAID that they do not provide this service, so alternative arrangements can be put in place. Nurses who conscientiously object to MAID are still required to provide any routine care that is not related to medical assistance in dying. They must continue to provide safe, compassionate, competent, and ethical care until alternative arrangements are in place to address the patient's plan of care. Next slide, please. Providing or assisting in medical assistance in dying can have a wide range of emotional impacts on healthcare providers. Many providers express moral distress when grappling with MAID. Some experience intense negative emotions and internal conflict, while others experience positive emotions through helping patients at the end of their life. Debriefing after MAID is an important component for supporting healthcare providers. It creates a safe space for the healthcare team to talk about the MAID process. It's an opportunity to share perspectives and feelings about the patient, and an opportunity for team members to reflect on their experience or how they are feeling. Debriefing after MAID is an important component for supporting healthcare providers. We encourage nurses to participate in MAID debriefing sessions with their teams. If you work independently or in an organization that does not have MAID debriefing sessions, we encourage you to find other supports, such as family, friends, colleagues, professional networks, or employee assistance programs. And now I'll turn it back to Carla.
Thanks, Natalie. Next slide, please. So we are excited to have Diane Gwartz, nurse practitioner, join us today to talk about her experience as a nurse practitioner with the MAID process. Diane Gwartz has been a nurse practitioner in primary healthcare since the year 2000 and a registered nurse since 1985. She has worked in a variety of settings, focusing on primary care for the past 18 years. In 2018, Diane became involved in medical assistance in dying and has been an active assessor and provider in her community in Niagara since that time. Diane will be speaking from her practice experiences, and we wanted to signal that this may trigger difficult emotions for some of you hearing this. I will now turn it over to Diane to describe her practice experiences, provision processes, and the importance of self-care. Over to you, Diane.
Next slide, please. Thank you very much, Carlin. And it is my pleasure to be here today presenting on my personal experiences and processes, which are entirely based on the community. So I cannot really speak to experiences for hospital and hospice type settings, which I'm sure may be a bit different. Also, I'd just like to mention that the changes we've been hearing about in today's presentation have really just occurred. We're not even 2 months in to the passing of Bill C7. So as a community of professionals, MAID practitioners are working through what the new processes will actually look like for us and for our patients. So in terms of my practice experiences, I'd like to first start off saying that MAID has enabled me to give control to those who have lost control through their disease process. My goal is for them to have a peaceful, calm passing and to relieve their suffering. Most patients and families are incredibly grateful to have this opportunity, for them to be together, to be at home, to leave on their terms, to avoid what they fear most, which is often pain, dependence on others, or having others watch me die. Many of my patients have watched other close family members die slowly and painfully, and they want to spare their families that experience. It's not always about them, it's about their family as well. My personal experience of MAID is different than most, as during my training, my mother had a medically assisted death. So I have both the family perspective and the professional perspective, which I believe has helped shape me and my approach to MAID. I must say that most provisions go very smoothly, but I have had a few that were prolonged. But in the end, the patient was not aware and they didn't suffer. And that's our goal. Might have been a bit stressful for me and for the family, but it wasn't at all for the patient. What I often find the most stressful is actually the assessment process. Defining eligibility can be quite complicated in some patients. Many, maybe even most up until now, have been quite straightforward, but there are some that are complex. With the new non-reasonably foreseeable natural death track, the assessments will likely be more involved and time-consuming. However, as mentioned, C7 includes 90 clear days from assessment to provision in order to support the time that we need to ensure that we are adequately assessing our patients. The MAID professional community is unbelievably dedicated, supportive, and helpful. We have a professional association called the Canadian Association of MAID Assessors and Providers, referred to as CAMAP for short. And through that, and on our website, we have access to a forum that is a huge resource. I'm on the forum daily, reading about comments other people have made. I often post situations that I'm not sure about and hypothetical patients to get input from others with more experience than myself. In addition, in Niagara, where I practice, we have 2 nurse practitioners and 1 family physician who provide MAID, as well as another family physician who supports us in doing assessments. And we have formed our own little community practice, which is very helpful in terms of coordinating referrals, getting second assessments done, supporting each other, and also being backup for vacations and other times when we might not be available. The CAMAP website has many practical guidelines. If you're interested in knowing more about MAID, I would definitely refer you to their website, which is camapcanada.ca, camapcanada.ca, and it includes things like medication protocols, which are very helpful. I'd also like to mention that funding for nurse practitioners in the community who want to provide MAID services has been an ongoing issue in Ontario and throughout the country. We are working towards resolution, but we are not there yet. For myself, I've always felt privileged to be part of this very personal experience And I am proud that as a nurse, I can provide this care. Next slide, please. So the important thing about understanding provisions is, just like in nursing care, they are patient-centered. And we try to keep the patient at the center of the process always, including setting the date and time. It's usually set by the patient when it's meaningful to them. Sometimes it's as soon as possible. I've had people who have chosen to have their MAID procedures on their birthdays, on their anniversaries, various things like that. One patient tried very hard to find a date that wasn't correlated to anything else that was going on in her large family, trying to avoid birthdays and anniversaries so that it wouldn't have a negative impact on anyone. For me, the shortest time from assessment to provision was about 10 minutes. It was an urgent provision. I knew leaving the house that provision was going to happen immediately after assessment if the patient met the eligibility criteria. And the longest was 2 years. But typically it's about 2 to 4 weeks. The provision is usually done in the patient's own home where they feel most comfortable, very often in their bed or in a comfortable chair like a lift chair. I have done one provision in a cremation service, but I've heard of lots in backyards, parks, hotels. And this weekend, we have the opening of MAID House in Toronto, which is a community facility which provides a home-like environment for people who want to have MAID. And their website is maidhouse.ca if you want more information on that. And if there are some providers on this webinar, then they've asked me to let people know that they are asking people to go online and register with MAID House. So COVID has affected all of our lives and impacted us in many ways. In terms of MAID, I think there are lots of patients who are trying to avoid being in hospital and separated from their families, but mostly it has impacted those who can be present, which can be very difficult for patients and families. Normally, it's the patient who decides who they would like to be present at their MAID provision. And sometimes it's no one, and sometimes it is a crowd. Sometimes everyone is in the room where the procedure is occurring, and sometimes some of the people are in another part of the house or maybe even outside. It's really, again, just up to the patient and the family. So once the details are set and prior to the provision, the LIN orders have to be sent out in order to arrange for IV insertions, and a prescription is sent to a pharmacy to arrange for medications. We can also get our medication kits through the LIN, but I prefer to use a local pharmacy. We always need 2 viable ports for access because medications are given through IV or intravenously. If a patient has a viable PICC line or some other kind of access, then that can be used in addition to one IV. And I must say that I am so grateful to the nurses who support us with our provisions, coming and doing the IVs, which quite honestly are the most painful and often the most complicated part of a provision. Shout out to Barb, who's on this webinar with us. She is one of the nurses who supports us and has been incredibly flexible and kind in the work that she does with us. So when I arrive, the first thing I do is I confirm capacity as well as get consent once again from the patient. I then go into another room, draw up and label my medications, which takes about 10 minutes and allows the family to have some quiet time together. As mentioned, from the onset of the MAID process, patients are informed that their consent can be withdrawn at any time, right up until the initiation of medications. So immediately before starting to administer the first medication, I give my patients the opportunity to withdraw or give their consent to continue with the procedure. I have never had anyone who withdrew their consent at that point. There are 4 medications that are used: midazolam, lidocaine, propofol, and rocuronium. My experience is that most patients will go into a nice deep sleep with the midazolam, and they often pass during the propofol. But the procedure is that we complete the protocol, all the medications for all patients, regardless of when they have stopped breathing. And because these medications are all given as IV push, it takes just under 10 minutes to administer the medications. Once the medications are completed and the patient is no longer breathing and the heart has ceased to beat, we pronounce death and then contact the coroner's office. With that, we also complete the medical certificate while we wait to speak with the nurse practitioner investigator who calls us back from the coroner's office. Once we've spoken to the nurse practitioner investigator to give details of the indication, medication used, and any details from the provision that they want to hear about, they also speak with the family, which gives the family an opportunity to provide feedback. Once I've cleaned up and the family has contacted the funeral service, I give my condolences and at that point usually leave the home. I'm often in the home for about 1 to 2 hours. Sometimes it can be less and certainly sometimes it can be more, but that's probably an average. Once I'm home from the procedure, then there's quite a lot of documentation that is sent to the coroner's office. And that completes that process. Next slide, please. So in terms of self-care, I think it's really important to acknowledge that MAID is an intense emotional experience. I rely heavily on the support of family, friends, and colleagues, especially when I may have a more difficult experience. I try to ensure that I have time through the day to reflect and process the experience each time that I provide MAID. Although we don't have official debriefing in the community, I often find that I chat with the nurse and also the family after a provision just to go over any of the details and mostly just to reassure ourselves that the patient was very peaceful and went comfortably. My favorite self-care activity is to go for a hike. I love to be physically active and to be in nature. I find that very healing. But since that's not always possible, sometimes I just bake or quilt or even eat licorice all sorts because that's a comfort treat for me. To be honest, I've also had some distressing emotions related to home visits and the care that some of my patients are receiving. The story of their journeys is often very hard to hear. This will likely be more intense as we receive more requests for assessments for people who may qualify for non-reasonably foreseeable death, track 2. And dealing with the ethical implications of MAID, and now with the changing legislation, is also very heavy. I have found journaling and talking situations through with colleagues, as well as reconciling what others on the CAMAT forum discuss, to be very helpful. I know that as we continue to evolve the work that we do in MAID, I will continue to be challenged in terms of my ethical beliefs, but I am committed to the process and to making this option available to patients. I admit that I've sometimes found it difficult to balance my need to advocate for patients and my desire to not take over their primary care. With a non-reasonably foreseeable natural death, this will be even more challenging as the requirement to ensure patients are aware of their options for care is built into the process. It was implied through informed consent in C14, but it wasn't an obligation. I can tell you that I've had many sleepless nights struggling with patient care situations, but I've never had trouble sleeping after a provision. I think it's because I agree with the principles of MAID and I believe in the processes and safeguards. And it is so reassuring to see people who have been suffering so significantly to pass so peacefully. The recent changes in legislation are unknown territory, and we need to give ourselves time to adjust and work through what we are comfortable with, as well as finding the resources we need to fulfill the new requirements and opportunities. And this will take time, and I think it's essential that we give ourselves that time. So finally, as a nurse, I've always been committed to patient-centered care and patient choice. For me, it is an honor and a privilege to support patients and their families through this meaningful end-of-life journey. That's it.
Well, thank you so much, Diane. I think I speak for all of us in thanking you today for sharing your experiences and for triggering emotions in us that really validate that this is a difficult topic to navigate as nurses. You are clearly making a difference in the lives of your patients and your families, and we appreciate your openness to sharing and speaking from your heart with us today. So thank you. To the rest of the group that's here on the call with us, we have about 15 minutes for questions, and many have been coming in during the course of this presentation. But if you still continue to have questions and didn't know where to send them, please submit your questions by typing them into the Zoom chat feature and directing them to myself, Amanda Laird. You can indicate who your question is for, if it's for Diane or CNO staff directly. And if we don't have a chance to get to your question today, we will ask you to put it into our practice support email and we will get back to you directly through there. Okay. I'm now just going to turn over for a few questions. Many have been writing in to ask about the web link that Diane was sharing for the Canadian Association of MAID Assessors and Providers. So I will add that into the chat for us so that everyone has that. Just hold on to that, but we will also be sharing all of this information with you on the slides and with all of our resources that will be on our website. So I will get that in the chat for you. First question, I'm going to turn over to Carlin. Carlin, if you can just put your camera on there and maybe answer our first question, which is an employer permitted to preclude hired nurses from acting as a witness to a request for MAID?
Thanks, Amanda, and that's a great question. Given that CNO is we regulate nursing practice, we don't have any jurisdiction over employer policies and procedures. So it ultimately is up to the employer to determine whether they would like the nurses under their employ to be witnesses for MAID. So again, we have to sort of think of a nurse's scope of practice as their legislative scope, which this new change in Bill C7 does permit, but also what do the employer policy state to sort of whittle it down to what the nurse can do at the point of care. So really it is ultimately up to the employer to determine whether they would like their nurses working for their organization to be witnesses for the MAID process.
Great, thank you very much, Carlin. Question for Diane. If you are the person that is the witness to the request, so your clinician 8A, for example, can you do one of the assessments and or the actual MAID procedure as well?
So the legislation is very clear that although nurses are able to be a witness, they are not allowed to be involved in the assessment or the provision. So the answer to that is no. If you are involved in the assessment or provision of MAID for a patient, you are not allowed to be a witness to their formal request.
Great, thank you so much, Diane. And one for Romy. If someone was considering MAID as an option, would life insurance still provide coverage for spouses on that person?
You know what, that would be outside of the scope of what a CNO or I'd be able to answer. That would be something to check with their insurance company directly and potentially seek some legal advice. Referrals, if people want to get in touch with lawyers doing that particular kind of law, I'd suggest getting in touch with the Law Society of Ontario, which has a function to link people to lawyers for those consultations.
Amanda, can I just jump in for a second? One thing I didn't mention that that this question brings up is life insurance or other issues related to a MAID death. And in Ontario, we do not identify on the medical certificate of death that the cause of death was MAID. There is no mention of MAID at all. We use the eligibility criteria, medical condition as their cause of death. So there is no paper trail from the MAID process that gets to any people who might see the death certificate.
Great, thank you, Diane. A few questions for you, Diane, if you don't mind. Just one of the first questions was, can you share any stats on MD versus NP administration of MAID?
Oh, I should be able to, but I don't know them off the top of my head. Some people do. There is a report. It's in the link to it is with the resources. So I think it was 2019 stats from Canadian federal stats on the provision of MAID in Canada. Now, I can't even think of what the title of it is, but, and it's very clear in there. There's a pie chart and it tells you how many are nurse practitioner and the different specialties, because it's not only family physicians who provide MAID services. And in Ontario, we also have those stats. They come from the Chief Coroner's office. There's it tells us the number of, they call them independent nurse practitioners versus physicians who have provided. And again, I don't know what those numbers are. I'm going to say maybe somewhere around 20%, but we don't know from that the frequency. So if a person has provided MAID once, then they show up equal on those stats to someone who may have provided 50 times.
Great, thank you. And is it reasonable to think that people may state that they have been mentally affected by the pandemic or other issues and then opt for MAID in 2023?
Well, I guess people can request assessments based on any criteria, and we are open to doing assessments for people and look at their eligibility criteria. We don't make that decision before we start the assessment, but we also don't know what the eligibility criteria are going to look like for mental illness if and when that is passed in 2023. You know, that's the timeline the government has set, but as we know, those timelines are often extended. We assume that people will have to have a diagnosed mental illness, that medical care has not been able to provide exceptional options in terms of relieving suffering. And that's what we think it will look like. So I'm not really sure from that question whether they're saying that somebody could just say, oh, the pandemic was really hard on me, I don't want to live anymore. The answer to that, I would think, would be that would not meet eligibility criteria. Again, we don't know for sure what it looks like, but you know, if it's someone who has really suffered with mental illness for a long time and the pandemic was a tipping point for them, that's quite possible. You know, that may be part of the picture when the time comes.
Thank you very much, Diane. Next question for you, Diane, if you don't mind. Can you clarify where you are reporting as part of your aftercare? You've indicated you have to report all requests for MAID. Is that through the federal portal still?
So Roni said that it's on on the federal website what we have to do now. I actually have not received any information. I have done federal reporting for patients who have passed prior to their provision, and also for patients who I received a written request from, but then chose not to have MAID. In our community, hospice does not allow us to go in and do MAID in their facility. So if patients decide to go into hospice after they've been approved for MAID and started that MAID and had that MAID process, then we would report for that. But the new reporting requirements, I'm actually not certain how that goes. Most of our reporting in Ontario goes through the Ontario Coroner's Office, and they gather most of the information that is federally required. And so we are continuing to do that. There has been a little bit of confusion for us because the Coroner's Office actually has started asking us the questions in terms of some specific individual characteristics for the patient, like race, and we don't actually have guidelines from the federal government what that's supposed to look like in terms of what information we are supposed to be gathering. So people are choosing kind of to do their own thing in terms of defining. One of the questions is disability. Did the patient have a disability? Well, that's a really hard question to answer because that can mean so many different things, and obviously the person was unwell, but anyway, some people are choosing to just answer I don't know, and other people are forming their own ways of asking those questions to the patients so that they can give the information to the for reporting that reflects the patient's own perspective.
Thanks, Diane. And I'm not sure who to direct this to, but maybe either Diane or Carlin even, if there is any way you can expand on the requirement to be an expert in intolerable suffering. Not sure if that was the expertise or if that's a clinical judgment by a provider, Diane or Carlin?
Do you want me to speak first, Carlin? Okay, so it's not really clear what the expert is supposed to be commenting on. It's certainly, I don't think, the concept of intolerable suffering, because intolerable suffering has always been defined by the patient, not by the assessors. So the concept of expertise as opposed to expert is also very important, and we don't really have definition as to who qualifies for expertise. We're hearing someone who's cared for somebody with a condition once has expertise in an area, but the idea around that is only related to non-reasonably foreseeable natural death. We don't have to have that kind of backup expertise with reasonably foreseeable. And it, as I think it was Romy explained, it's only if one of the assessors does not consider themselves to have expertise in the medical condition that the patient is applying for MAID related to. So I recently have started an assessment for a patient who would be in the non-reasonably foreseeable track, and spoke with their gastroenterologist because it's a GI issue, and he just said he thought he met all the eligibility criteria. Probably that conversation is enough of a consultation that I could just document it, but I just asked him if he could write a little note. I sent him kind of the criteria that I'd like him to comment on, and he'll just fax a note, which I would attach to my assessment information.
Thanks, Diane. And just to add on to this, that we did receive clarity from Health Canada, and they stated to us that the law does not limit the number of practitioners with expertise that may be consulted, and specialization or certification is not required. And so that so out of the 2 practitioners, they could continue to consult until they feel that they have enough expertise to look into the condition causing the patient's intolerable suffering. I do recall that from our conversations from Health Canada, that they'll try to put these clarifying questions, especially around the expertise point. They'll put these FAQs up live on the federal website shortly, so hopefully more to come, and we'll be happily to highlight these resources on CNO.org's MAID webpage.
So just a couple of thoughts to add on to that. So one of the things that I thought of when you were speaking, Carlin, is in addition to getting lots of input from various experts or people with expertise, we should also point out that patients can request as many MAID assessments as they want or need that they're willing to tolerate. So just because a patient has been declined eligibility by one MAID assessor, or 2 or 3 or 4, they can continue to request. And it's not uncommon for people to be declined by some practitioners and then be approved by 2 and be able to go on and have MAID. So I think that that's an important piece that people should know as well.
Okay, thanks. Thanks so much. And Diane, I'm just going to do this one final question, I think, to wrap up some of our time. But Diane, there was a question that came in that said, when MAID is denied and a patient disagrees, what happens in that instance?
Well, that follows what I was just saying. So then they would request more assessments, and I guess they just keep requesting assessments until they either come to terms with the fact that they don't meet the eligibility criteria, or they would be found eligible by different practitioners. And, you know, it's like a second opinion kind of concept. We know in healthcare, we don't all have the same ideas. We don't all view what might look like very specific data equally. So what some people may feel meets reasonably foreseeable, others might not, which is actually going to be another interesting, potential situation we will find ourselves in, that I do an assessment on a patient, spend a whole lot of time doing the assessment, and tell the patient that they're eligible based on the track 2 non-reasonably foreseeable. They don't feel that they should meet that they want to be assessed or want to be found eligible under reasonably foreseeable, probably because of the timeline, 90 days versus as soon as we get our 2 assessments done. And so may choose to have additional assessments trying to confirm that they meet the criteria for reasonably foreseeable. And as was explained in the presentation, we don't have timelines for that. It is very subjective. And within the CAMAT forum, we will have lots of conversations. And it was one of the things I struggled with as a new MAID provider, was how do I decide that a patient is reasonably foreseeable? It's not based on a prognosis of any certain amount of time. We can't always define decline. I mentioned that I had a patient who from assessment to provision was 2 years, and people would say, well, how can that be intolerable suffering? How could they meet the eligibility criteria of intolerable suffering if they were able to go on living for another 2 years? Well, interestingly, she was suffering intolerably, but through the assessment process and with the criteria of informed consent, we suggested that she look at alternative palliative care strategies in terms of her pain management, which actually really helped her. And it was almost 2 years before she felt that she wanted her MAID provision. And then she was told, it was last March, and she was told by someone who was incorrect that we weren't doing MAID because of the pandemic. And so she waited a few months and then contacted me to say, are you doing them yet? And I was like, but anyways, there's lots of interesting questions around that. In my experience, patients who I have declined in the past, I have always told them that they might meet non-reasonably foreseeable natural death, because we knew BLC7 was going to be coming at some point. And they were satisfied with that. They, all of the patients that I saw at the time, I had told right from the beginning that we had this criteria. When I told them why I thought that they did not meet the eligibility criteria, they were satisfied. The time that I have found a little bit dicey, I would say, is around people who have a coexisting mental health history, specifically if they're suicidal. And because we have the criteria now that we need to make sure that mental illness is not the driving illness that's the request is around, we often ask for a psychiatric assessment to determine capacity, but also to assess for the involvement of the mental illness in the request. And some patients have been very resistant to having that psychiatric assessment.
Thanks so much, Diane. Really appreciate you answering some of these difficult questions. Just in the essence of time, I apologize if we didn't get to your questions today. I know they've been coming in fast and furious as we've had some time to reflect on the presentation. Please feel free to check out our website. There will be a guidance document there that's been updated. We have our FAQs and infographic. So there's lots of information there for you, including a lot of resources. And if you continue to have questions following your review of those documents and information, please feel free to write into practicesupport@cno.org. But before we end today, I would like to take the opportunity to thank everyone who was presenting. Carlin, Romy, Diane, Natalie, thank you so much for preparing this presentation for all of us today. And I'd like to also thank the professional associations for their input on our guidance document and the resources that can be found on our website. Again, a big thanks to all of you for taking the time to attend today's session. The slides, recording, and resources will be available within the next week or so. As we get close to Nursing Week, I would also like to thank all of you on behalf of the CNO for everything you do in support of patient safety. Take good care of yourselves and each other, and have a wonderful Monday. Thank you, everyone.